Good morning, everybody. This is Samiullah Khan from Giridhar Ramnarayan Institute of Commercial Practice, SJP Campus, Bangalore. In this session, I will explain the concept of the appointment of the company secretary under the chapter Company Secretary. Under this session, we will discuss appointment of the company secretary, procedure for appointment of the company secretary, and provisions for appointment of company secretary. This session is conducting with an object to acquire the knowledge of company law and secretarial practice and to acquire the knowledge and understand the appointment of the company secretary. As comes to the concept of appointment of company secretary. As per the Indian Companies Act of 1956, it is not compulsory for the companies to appoint a secretary. However, all the companies appoint the secretaries. But as per the Companies Amendment Act of 1974, it is an obligatory for every company having paid up capital of rupees 2 crores or more, which is amended to rupees 10 crores, to appoint a full-time secretary. Further, it is obligatory for every company having a paid up capital of rupees 2 crores or more to have a whole-time secretary, which is amended to rupees 10 crores according to the Indian Companies Act of 2013. Nothing but the company having a paid up capital of rupees 10 crores is required to appoint compulsory, mandatory to appoint a full-time or a whole-time company secretary. Therefore, these provisions highlights that every company in India having a paid up capital of rupees 10 crores or more should appoint a company secretary, whether the secretary is a full-time secretary or whole-time secretary. Then after this comes to the next concept is the types of secretary. There are the two types of company secretary are there, which are as follows. The first one is a first pro term or provisional secretary. Secondly is the regular secretary. Comes to the first one, the first secretary or a pro term secretary or a provisional secretary are those secretary which are appointed by the board of directors of the company before the incorporation of the company. He is called as the first secretary of the company because during the life of the company he is the first secretary. He is called as a provisional secretary because he is holding a temporary period. As soon as after the incorporation of the secretary, incorporation of a company, a regular secretary is appointed in the place of the provisional secretary or a first secretary of the company. Therefore, this secretary is called as a provisional secretary. Therefore, I can conclude that now the first secretary refers to the secretary who is appointed by the board of directors before the incorporation of the company for attending all the preliminary work, that is the work before the incorporation of the company. Now that secretary is called as a first secretary of the company. Then comes to the next one. It is the second one is a regular secretary of the company. The regular secretary is a secretary who is appointed after the incorporation of the company. He is a permanent secretary or a regular secretary of the company. He holds the office till the next annual general meeting of the company. The shareholders meeting. Now the secretary can be approved. Now comes to the next concept is here the procedures for the appointment of the regular secretary of the company. The following procedures are followed for the appointment of the regular secretary of the company. The first one, passing of a resolution. At the first board of directors meeting, a resolution should be passed for the appointment of the regular secretary of the company immediately after the incorporation of the company. The next one is the execution of service agreement. A service agreement is executed between the company and the secretary, approving the terms and conditions of his appointment. This is the second step. That is the execution of service agreement. Third one, recording of his appointment in Register of Officers. As per Section 303 of the Companies Act, the details of regular secretary should be entered in the Register of Officers of the company, because a secretary is also one of the officer of the company. He is an executive head of the company. Therefore, his appointment details should be entered in the register of the officers of the company. Next one, filing of returns of the appointment with the registrar. As per the section 303 of the Companies Act, a return form number 32 containing the name, address, qualification, power, nationality, etc. of the company secretary must be filled with registrar of the companies within the 30 days from the date of the appointment of the company secretary. That is the filing of returns of the appointment with the registrar. Within 30 days they have to appoint, they have to file the details with the registrar of the company. The next step is the notifying the other company. If a part-time secretary who is functioning as a secretary in any other companies is appointed as regular secretary, then intimation, the information of the appointment of the regular secretary is given to other companies within 20 days of his appointment. The next one, passing a special resolution. If a director or a relative of a director is appointed as a regular secretary, then a special resolution is passed at annual general meeting approving his appointment. The next, disclosure of interest by the director. If any director or a relative of a director is appointed as a secretary of a company, then the director is in disclosure his interest at the board meeting that he does not take part in any discussion relating to the appointment of the company secretary. The disclosure has to be made by the director who is appointed as a company secretary or a relative of a director who is appointed as a company secretary. The next one, obtaining the permission of the central government. If a director is appointed as a company secretary, then a prior permission of the central government has to be obtained. Now this permission is required only when a director or a relative of a director is appointed as a company secretary. Now these are all the procedures for the appointment of a company secretary. The procedure is passing a resolution immediately after the incorporation of the company at the first board of directors meeting. Execution, secondly, execution of service agreement with the terms and conditions of the appointment of the company secretary. Recording in register of officers of the company secretary details. Filing of returns of the appointment with the registrar of the companies. Notifying the other companies about the appointment of the regular secretary. Next, now the passing of a special resolution. Now this step is applied only when a director or a relative of director is appointed as a company secretary. The step number 6, 7 and 8, it is applicable only when a director or a relative of a director is appointed as a company secretary. Yes, this is the procedure for the appointment of the company secretary. Now comes to the next concept is the provisions for the appointment of company secretary. Now the Companies Act laid down the certain provisions for the appointment of the company secretary. Such provisions are as follows. First one, appointment of only an individual. Only an individual person can be appointed as a company secretary, other than the individuals such as associations, firms or a body corporate, etc. cannot be appointed as a company secretary. Next one, appointment of company secretary is mandatory. Now it is mandatory for all the classes of the company to appoint a whole-time secretary in the following cases. The first one, every listed company has to appoint a whole-time secretary. Second one, every public unlisted company having a paid up capital of rupees 10 crores or more. And last one is every private company having the paid up capital of rupees 10 crores or more should appoint a company secretary. Therefore, the appointment of the company secretary is mandatory. It is compulsory for all those companies having the paid up capital of rupees 10 crores or more. The next one, board resolution. Immediately after appointment of the company secretary, a resolution should be passed at the board of directors meeting immediately after the incorporation of the company. This is the first board of directors meeting is to be conducted after the incorporation. In this meeting, the secretary, a resolution is passed for the appointment of company secretary, that is regular company secretary. The next, terms and conditions. This resolution, which is passed in the board of directors meeting, should clearly specify the terms and conditions for the appointment of company secretary, including the remuneration also. The next, entitled to become the director of any company. A company secretary is entitled to become a director of a company with the permission of the board of directors. If there is any chance, then a secretary can become a board of director also. But for this, a central government permission has to be obtained. That we have discussed in the previous discussion procedure for the appointment. We have discussed according to the section 303, they have to obtain the central government permission, and a director has to disclose his interest in the appointment. The next, entitled to hold office only in one company. A secretary can be act as a part-time secretary for more than one company, but a whole-time secretary cannot be act for more than one company. Therefore, it is clear that a company secretary shall not hold the office in more than one company. However, he may hold the subsidiary of the company at the same time. If there is a holding company and subsidiary company is there, then in that situation, in a subsidiary company, the company secretary can be also a company secretary. The next, filling the vacancy. If the office of the company secretary is vacated, resulting the vacancy shall be filled by board at the board of directors meeting within the 6 months from the date of such vacancy. The next one, punishment for contravention. If a company contravenes or does not follow the above provision of the Companies Act, shall be punishable with a fine which shall be not less than 1 lakh but may be extended to rupees 5 lakhs. Excuse me. However, therefore, if the provisions does not followed, in that situation, failure to comply with the provision are eligible with a fine of rupees 1 lakh to 5 lakhs. Comes to the next one. Now, these are all the certain provisions of a company, appointment of a company secretary. Now comes to the next concept is a multiple choice questions. Now the following are the some of the multiple choice questions for these sessions. The first one, the first secretary of a company is appointed by option A, promoters, Option B, directors. C, bankers. D, auditor. What is the answer? The answer is option A, promoter. The next one, the first secretary of the company is called option A, pro tem secretary, option B, provisional secretary, option C, both A and B, option D, none of the above. The answer is, what is the answer, my dear student? Yes, the answer is option C, both A and B. Now the first secretary of the company is called as a pro tem secretary, and also it is called as a provisional secretary. The next question, the first secretary of the company assists in the formation of the company by attending option A, preliminary work, option B, helps to prepare prospectus of the company, option C, helps to prepare memorandum and articles of association of the company, option D, all of the above. What is the answer, my dear student? Yes, the answer is option D, all of the above. Then comes to the next question. The pro tem secretary of a company is a provisional secretary, option A, option B, permanent secretary, C, regular secretary, D, all of the above. The pro tem secretary is a provisional secretary. Therefore, the answer option A, provisional secretary, is the right answer. Comes to the next question. A regular secretary is appointed by the board of directors according to the provisions of which act? Option A, the Companies Act of 2013. Option B, the Income Tax Act of 1961. Option C, the CGST, that is the Central Goods Sales Tax Act of 2017. Option D, the State GST Act 2017. What is the answer, my dear student? Yes, the answer is option A, the Companies Act of 2013. The next, a resolution is passed at the directors' meeting to appoint a company secretary, B, watchman of the company, C, P1 of the company, D, gardener of the company. What is the answer, my dear student? Yes, it is a company secretary. Option A is a correct answer. The next question, the procedure for appointment of a company secretary are: option A, a resolution is to be passed at a directors meeting. Option B, particulars of appointment must be submitted to the company registrar within 30 days of his appointment. Option C, secretary should enter into a written agreement with the company. Option D, all of the above. What is the answer, dear students? Yes, the answer is D, all of the above. All of these is the correct answer. The next question, if a person appointed as a secretary, he has to notify to the other company where presently working within option A, 30 days, option B, 20 days, option C, 15 days, option D, 25 days. What is the answer, my dear student? Yes, the answer is option B, that is 20 days. Appointment of a company secretary is purely on the basis of option A, share qualification, option B, educational qualification, option C, statutory qualification, option D, non-statutory qualification. What is the answer, my dear students? Yes, the answer is statutory qualification. If a company secretary possesses certain statutory qualification, then only he or she is eligible to act as a company secretary. The others are secondary qualifications. The next question. Public company can commence the business after obtaining option A, certificate of commencement of business, option B, the prospectus, option C, the memorandum of association, option D, articles of association. Yes, what is the answer, dear students? The answer is option A, the certificate of commencement of business. Yes, these are all the certain multiple choice questions are there. After this, now comes to the next session outcomes. After completion of this session, now the outcome is the student will come to know who will appoint the company secretary and analyze and apply the provisions of company law regarding appointment of company secretary. Then these are all the books of references. Thank you. I hope this sessions is you followed and understand. Now thank you one and all. We can come with the next sessions. Till that,